Hi, I'm Brent Stafford, and this is RegWatch by RegulatorWatch.com. Pressure is growing on the Ontario provincial government to pull back on key aspects of its new anti-vaping law before it's implemented. Government health officials and Liberal politicians are struggling to reconcile the crackdown with the mounting scientific evidence that shows vaping is not only a safer alternative to smoking, but that it also saves lives. Pushing the point, representatives from the Canadian Vaping Association, its government relations firm, and legal counsel met with the Associate Health Minister, Dipika last week. In that meeting, the CVA's constitutional lawyer, Doug Elliott, delivered a withering legal opinion on the constitutional validity of the law. Elliott is well known for his work on landmark cases such as same-sex marriage and religious freedom, with many Supreme Court appearances to his credit. He says Ontario's anti-vaping law is arbitrary and unconstitutional, going so far as to say that the Supreme Court's recent decision on assisted dying could help secure the right to vape. RegWatch caught up with the venerated lawyer in Toronto a few days before the meeting. You stated in your opinion that the proposed regulations in Ontario remains vulnerable to a charter challenge. Why is that?
It's violating federalism, as a violation of Section 2, the freedom of expression provisions of the Charter of Rights, and Section 7, which allows adults to make the choices that are important to them in their life, particularly choices around their health. And your viewers in British Columbia will be familiar with the Insight decision, which said, a government can't interfere with people making healthier choices unless there's good scientific evidence to the contrary. And there just isn't any scientific evidence that imposing these restrictions is justified.
Well, let me ask you about that. You mentioned in your opinion the Royal College of Physicians. We just covered their report a couple weeks ago. It seemed to be a very conclusive report. How did you evaluate the actual report and its impact? What impact could it have on the actual regulatory process?
Well, I think it's going to have huge impact. First of all, it's a highly respected body. They did a very thorough study. This isn't some crank in some faraway land. These are very respected scientists who are respected by their peers in Canada. And I know from my discussions with people, healthcare professionals in the province of Ontario, that it attracted a lot of attention in the medical profession. And I think a lot of people who hadn't really followed the vaping issue very closely and were maybe buying the public health arguments that there was something wrong with vaping, that it was harmful, suddenly woke up and paid attention and realized that there was credible scientific evidence that this is a healthy choice for a lot of people.
When you look at the regulations currently, coming up here in Ontario, how would you characterize them?
I find these regulations really quite arbitrary, and I find them draconian. Yeah, I find they really are more severe than the regulations that are in place for any other lawful consumer product in Ontario. And again, I ask myself, what terrible thing are they trying to protect the public against?
Government says it's to protect the children.
Well, the problem is that the law says that you cannot sell these products to people under the age of 19, and I don't think there's anything wrong with that. The whole point of this act, according to the minister, was to protect children. As soon as you ban sales to people under 19, you've protected children. And the CVA totally supports that. And are there going to be people who sell to children despite that? Of course. And those people should be charged and fined. That's a very bad thing to do, is to break the law and to sell to children. But when you know that the product is just being sold to adults, why are you interfering with the choices made by adults, especially when those choices can save their lives?
And that's really where the Charter 7 portion comes in, doesn't it?
Absolutely. Section 7 is all about protecting the rights of adults to make important choices about their own lives, especially choices about their health. The days of the nanny state and the doctor and the government telling you what choices you should make about your own health should be consigned to the history books. Every informed adult should make their own choices. After all, the Supreme Court says we can choose to die if we want to. So why shouldn't we be allowed to choose to live?
they've given us the right to end our lives, but yet while we live them, we don't have the right to choose to help make our lives better.
It doesn't make sense to me as a matter of public policy. And if the Supreme Court of Canada is going to allow us the right to choose techniques that will accelerate death, they're surely going to allow us to choose techniques to extend our lives.
That should give some vapors some hope.
I sure hope it does. I can tell you we're fighting hard for them.
So part of your legal opinion and what's happening in terms of getting it out there, and also with you joining us here on RegWatch, is that a part of the pressure of letting the government know that you believe that there's a strong chance that you could win if you do go to court?
Well, we are pursuing a two-pronged approach with the government. The first is hit them with the science and to let them know that the emerging scientific consensus is that they got off on the wrong track to start off with, and they've got a chance to change course now.
So the RCP report may in fact actually give politicians an out?
Absolutely, and that's what they need, I think, in some cases. Certainly in Ontario, they need some political cover. They need an excuse to back down because it's hard to say, I was wrong. But if you can say, I was mistaken and now I've got better evidence, it's easier. And the second part of it is to let them know that their constitutional foundation for what they're doing is pretty unsound. And so there's a good chance that it wouldn't stand up in a court of law, and so maybe they better rethink their policy for that reason too. It is a walk softly and carry a big stick approach right now.
Well, that's it for this edition of RegWatch. Before you head off, please like us on Facebook and don't forget to follow us on Twitter. For RegulatorWatch.com, I'm Brent Stafford.